Good morning, everyone. Hope you all are well this morning.
Good morning.
Good morning, Judge Morrow.
Good morning, Horace. Hope you're well today.
Yes, sir.
Can y'all hear me?
Yes.
Okay, thank you. Good morning.
Good morning.
I had a question for the state, for Gabrielle, Williams. Whoever's handling that case. Ms. Falk, you're on mute if you're trying to.
Yeah, I just realized that. Yes, I'm here.
Is this a first offense?
It is.
Okay, why are you? One second.
It cut off what you were saying.
That's because I cut myself off. Okay, so, why are you asking for license suspension of 1 year? Because that's not the statute for a first.
Well, due to the fleeing and attempting to elude an officer, I think it's appropriate. Obviously, you can ask the judge for something different. I know there is a mandatory license suspension, and obviously she can get a certificate of first offense.
Right, and it's for a first offense, it's usually 120 days.
I understand.
All right, I haven't spoken with her yet. They're supposed to be calling me at some point. She's also been in 154 days at this point with no. She got bound over from Roswell, but hasn't seen a judge since 54 days ago. We may be making a bond argument.
You're well entitled to do so.
Just give me a heads up.
Thank you. I appreciate it.
Okay. Your Honor, whenever you're ready, we could do position 57, 58, 59, and that's Mr. Bennie Wilson.
Okay.
And Judge, we're entering a not guilty plea and we'll waive formal reading.
Okay. Good morning, Mr. Wilson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir. Will I have a chance to say something?
No.
Well, if you'll listen to me first, and then I'll let you speak with Mr. White, and then whatever Mr. White decides, okay? All right, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Wilson. Mr. Wilson, you've been charged in case 23 CR 002735J with criminal trespass, in case 24 CR 00382J with criminal trespass, and in case 24 CR 004913J with criminal trespass and simple battery. Each of these charges carries with it a maximum penalty of year in jail and $1,000 fine. Do you waive formal reading of the accusation, Mr. White?
We do, Judge.
Mr. Wilson, how do you plead? Guilty or not guilty?
Not guilty.
Okay, Mr. Wilson will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date, sir. Good luck to you.
I told him we're doing it. Still came back. Not a trial date. We go? Yeah. Come on. Come on for one time. So, the other person.
Next, we can go to position number 24 through 25, Mr. Franklin. Good morning, Your Honor.
Yes, good morning. Let's see, what are we doing, Ms. Vigiletti, with, Mr. Franklin today?
Mr. Franklin would like to enter a negotiated plea this morning, Your Honor.
Okay, very good. Good morning, Mr. Franklin. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
It's okay.
Okay, good. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your hand down. Thank you, Mr. Franklin. Ms. Desiano?
Good morning, Your Honor. The state's offer in this case is time served 24 days. That would be from July 1st to July 15th of 2022, and then July 29th of this year to today, and the state will move to null pros position 25. And I'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
We do for the purposes of the plea. Your Honor, Mr. Franklin tells me his legal name is actually Laurence Franklin, L-A-R-A-N-C-E. He did miss court because he was in custody on Georgia Department of Corrections. So I'm gonna pull that record and share it with everyone just to ensure we do have the accurate information on the record for Mr. Franklin.
So is the first name still France?
It's L-A-R-A-N-C-E, Laurence Franklin.
Okay.
It's his legal name.
Okay, so Laurence Franklin.
Yes, Your Honor.
Okay. All right. Anything further?
No, Judge.
Mr. Franklin, it's my understanding, in case 22 CR 004254F, you wish to plead guilty to giving false information to law enforcement. Is that correct?
Yes, sir, I do.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Very satisfied.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
I give up all my rights, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Franklin.
Thank
Good
you,
luck,
sir.
sir.
Thank
I appreciate your
So-
positive personality. Good luck to you.
Ms.
Thank you.
Vigilante, could you spell his real first name one more time for me?
Yes, it's Laurence. And I just spoke to him a minute ago, but once I pull the Georgia Department of Corrections information, I'll share it with you as well.
Thank you.
Next, we could go to position number 47 and 48, Mr. Alex Tumblin.
And this is also going to be a negotiated plea.
It is, Your Honor.
Okay. Mr. Tumblin, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
I think.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down. Thank you, Mr. Tumblin.
Yes, Your Honor, on position 47, count 1, the criminal trespass is 12 months, serve 34 days, credit for time served 17 days. That's going to be from February 9th to February 11th and July 24th of 2024 until today. Balance suspended, stay away from 1093 West Avenue Southwest in Atlanta. Count 2 will be time served, 34 days, credit for time served 17 days. That is the same time period, and position 48, which is the FTA, the state is entering a null process to that charge. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. And that 1093 West Avenue Southwest address is the Krogman, Krogman School Lofts.
White?
Judge, we did, We just asked you to accept the pleas negotiated. Sorry, I'm distracted. Phone call.
And you stipulate.
So stipulated, yes.
All right, thank you. Mr. Tumblin, it's my understanding that in case 24 CR 0000703A, you wish to plead guilty to criminal trespass and possession and use of drug-related objects. Is that right?
Yes,
Are you under the influence of any drugs or alcohol this morning?
I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor, I am.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do.
Has anyone forced or coerced you to plead guilty?
No, Your Honor, they have not.
Okay, I'll accept the plea as negotiated, Mr. Tumblin. Good luck to you, sir.
Thank you.
Thank you, Judge.
Well,
Next, we can go to 28 to 31, Mr. Deshaun Johnson.
and these are negotiated pleas as well?
Yes, Your Honor. I did want to ask if Your Honor would consider allowing probation to go non-reporting upon completion of the terms. But aside from that, this is a negotiated plea.
Okay. Good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Johnson. Ms. Desiano?
Your Honor, for position 28, the state's recommendation for count 1, shoplifting, 12 months probation, served 34 days, credit for time served 17 days. That's April 13th to April 14th of 2020, and then July 23rd of this year to today, balance probated, taking complete an anti-theft course, 40 hours of community service, stay away from the BP station at 2320 Chester Ridge Road, and the count 2 shoplifting, 12 months probation concurrent with count 1. For position 29, the count 1 disorderly conduct, 12 months probation, served 46 days, credit for time served 23 days. That's May 17th to May 24th of 2023. And then July 23rd of this year to today, balance probated, stay away from the Chevron at 74 Northside Drive, and complete 8 weeks of anger management. Count 2, the criminal trespass, 12 months probation concurrent with count 1. This case will run concurrent with 20 CR 5723C, and the state will move to null pros position 30 and position 31.
Is you ready?
And I'd ask the
Yes.
defense to stipulate, Your Honor, to venue, factual basis, and ID for purposes of the plea.
And we do stipulate, Your Honor, these charges are from 2020, from a time when Mr. Johnson was much less stable. Since then, he has become a lot more stable. He was transient back then. He now lives with his father. He works at a 24-hour barber shop. And right now he's cleaning, but he's hoping to learn how to cut hair. He completely understands the terms of the plea, the anti-theft class, the anger management, the community service, and staying away from these 2 gas stations. And, because he will be paying for each of those programs as well as probation fees, if Your Honor would consider allowing him to go non-reporting and upon completion of the fees, it would be a huge help to Mr. Johnson.
Mr. Johnson, it's my understanding that in case 20 CR 005723C, you wish to plead guilty to 2 counts of theft by shoplifting. And in case 21 CR 003870G, you wish to plead guilty to disorderly conduct and criminal trespass. Is that right?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, no, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Johnson. When you complete the terms, it'll go to a non-reporting status. So the sooner you get this knocked out, the sooner that you won't be on reporting probation and have to pay those fees, okay?
Yes, sir.
All right, good luck to you, Mr. Johnson.
Thank
Thank you, Judge.
You're welcome.
We can go to position 15 and 16, Coleman. Coleman.
Is this Ms. Atai's case?
Yes.
it is, Your Honor. Good morning.
Good morning, Ms. Atai. Hope you're doing well this morning.
I'm good. How are you?
Doing well, thank you. What are we doing with Mr. Coleman today?
Your Honor, I received an email from Ms. Desiano and we're going with, well, I guess it's a negotiated plea, but it's a global resolution, including his other, open criminal trespass, 24 CR. And I don't know how that needs to be added on, 24 CR 0038088A.
Okay. Let's see. Ms. Lewis, do you have that?
No, I don't. Let me see. Can you say that number again? 24 CR what?
Oh, sorry, 24 CR 0038088A.
Okay.
I put it in the chat for you, Ms. Lewis.
Thank you.
That charge is also criminal trespass?
Yes.
Okay. Good morning, Mr. Coleman. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, please? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Yes, Ms. Desiano.
Your Honor, the state's recommendation for position 15 is 12 months probation, serve 126 days, credit for time served 63 days. That's from August 17th to August 25th of 2023, and then June 14th, 2024 to today. Balance suspended, stay away from 3072 Washington Road. For the add-on case, Your Honor, 24 CR 0038088A. State's recommending 12 months probation, serve 4 days, credit for time served 2 days. That's from June 13th to June 14th of this year. Balance suspended and a stay away from 3072 Washington Road. I'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
We stipulate, Your Honor.
And will not cross position 16.
Anything further, Mr. Ty?
Nothing further, Your Honor.
Mr. Coleman, it's my understanding that in case 23 CR 005071A, you wish to plead guilty to criminal trespass. And in case 24 CR 003808A, you wish to plead guilty to criminal trespass. Is that correct?
Yes, it is.
Are you under the influence of any drugs or alcohol this morning?
No, I'm not.
You've been represented by counsel. Are you satisfied with her representation?
Yes, I am.
Do you understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Coleman. Good luck to you, sir.
Appreciate you.
You're welcome.
Yes, thank you.
Who am I sending orders to?
I put the
morning, Judge
information in
Morrow.
the chat. I put the information in the chat. Everything go to Katrina Lewis today.
Thank you.
Good morning, Francois. I hope you're doing well today.
Thank you. I hope you are as well. Are we ready for positions number 38 through 41? That's going to be Porter.
Okay.
Yes.
And what are we doing with Ms. Porter this morning?
Your Honor, it's going to be a not guilty plea, and I know that you typically don't address FTAs, but I do want to request that you lift the FTAs in this case, which are the she's held on a $1,000 bond on each FTA.
Okay, let me see. So you're gonna file a waiver, is that right? Or would you like me to arraign her?
I'll file a waiver.
Okay. And may I get her history first? Ms. Hardy, good morning.
Good morning, Your Honor. Bear with me, I'm still working on her history.
Okay. Yes, Ms. Falk.
Yes, Your Honor. Just to go into a little bit of the background on the FTAs on her cases, that is correct. She is currently being held on a $1,000 surety bond on both. Both cases are out of Judge Besson's courtroom. The first failure to appear was July 19th of 2021 for a plea and arraignment calendar, at which point that was placed on in bench warrant status. On her second case, there was a bench warrant for her failure to appear at plea and arraignment on July 19th of 2023. So this is not just one FTA, it's two different FTAs on two different dates. I know often when we see FTAs, it's usually because the defendant just failed to appear on one date, maybe on two cases. This is two dates, 2 years apart, where she failed to appear. As for the cases themselves, the defendant has, just look at her cycles really quickly. The defendant currently has, it appears to be 31 cycles on her history. That includes her most recent offense, which is a probation violation for aggravated assault under 14 SC 125996. She received 5 years probation on that case in Fulton County on August 5th of 2014. She also has a family violence battery offense where she received 24 months probation. That's 13C 55509. That was out of DeKalb County State Court. She entered a guilty plea on that, as well as previous probation violations for an aggravated assault under 06 SC 48561. That was, again, a Fulton County case, and a simple battery family violence under a probation violation for simple battery family violence under 07C R 319863. So as you can tell, the defendant does have a history that involves quite a bit of violence, including 2 convictions for aggravated assault and 2 convictions for family violence. And so we are asking that the bond remain as set in this particular case, starting with the case that occurred in 2021. The report states that the defendant was at the MARTA station and threw a glass bottle at the passenger side window of bus 1818, shattering the glass. Winston Douglas was the operator of that, and the incident was captured on bus surveillance. At that point, she was suspended from MARTA from June 25th, 2021 to August 23rd of 2021. The second offense, which happened in 2023, that was an April 2021 offense, excuse me. Then there was a different offense that happened, which is the battery. On that case, the facts of that case are that on December 3rd of 2020, the officers were called to 1366 Graymont Drive Southwest. They spoke with the victim, who stated he and the defendant got into a verbal altercation that ended with her throwing a hot sauce bottle at him. The bottle hit him in the right area of his eyebrow, causing a small laceration, and he was taken to Grady Hospital. She was identified as, the officer was given a description by the victim, and she was identified based on that description and placed under arrest. The victim in that case was a Mr. Sorry, just give me a moment. Mr. Timothy Miles. So at this time, we would like to sound for Mr. Timothy Miles in case he is present today.
Laws is present and wishes to address the court. Now is your opportunity. Ms. Atai?
Yes, Your Honor. We didn't hear the pretrial report, but the cases that Ms. Falk was reading, it was 2013, 2014, and 2006. I don't know what her last arrest was, but I believe it would have been, these incidents. And sorry, so those are from 2020, 4 years ago, and 2021, 3 years ago. She is 57 years old. She is the mother of 3 children, one of which is deceased. She's lived in Georgia all her life. She did struggle with homelessness for a long period of time, Your Honor, but she has been living for the last 2 years at the Welcome House, where she receives mental health treatment, drug and alcohol treatment. She does suffer from cirrhosis. She goes to Grady often to treat her liver disease. She is waiting for a liver transplant. She walks with a cane. She has high blood pressure. And Your Honor, these FTAs, she tells me that at that time, it was during COVID. She states that she was getting mail at, I'm trying to see where it was, from the Presbyterian Church, and that closed during COVID. So I think for at least the FTA on the battery case, she wasn't able to receive mail because the church was closed. The other FTA, that incident date is 2021. She had a court date 2 years later. She's had a lot that has happened to her in her personal life. She did change address. Yes, she did not update the address, but she has been living for 2 years at the Welcome House. And she tells me that on August 10th, so in 4 days, her Social Security will be suspended, and she would be at risk of losing this housing that she's been, fortunate enough to find that's got her out of a cycle of homelessness. So I would like to ask that these $1,000 FTAs on each of those be lifted.
What is the Welcome House, Ms. Atai?
The Welcome House, it's on 234 Memorial Drive. It's a housing program where basically they, and she's on disability, of course, Your Honor. So basically the Welcome House, they charge you 30% of your monthly fixed income from your disability in order to provide you with an apartment.
Okay.
So it's a housing program, I guess aimed at providing long-term housing and to get people out of a cycle of homelessness.
Do you have her original bond there, Ms. Atai?
The original bond on the FTA?
No, on the battery and on the criminal trespass.
So I don't even see a first appearance on, let me see. I didn't even see a first appearance on the battery. And I think it was because of COVID. Maybe she just got a citation. I'm not sure. I didn't see a first appearance there. And I would imagine that she received a signature bond on this criminal trespass, but I don't know. I can look.
Okay, I was wondering if it went through pretrial or if she got if it was a citation or if it was through the jail. I know it was, well, at least one of them was, well, both of them would have been in COVID.
Right. She got a copy of charges on both, Your Honor. So she did receive a copy of charges as to both and wasn't given any kind of bond.
Okay. All right. I'm going to give her the opportunity to make this right, Ms. Atai, given what you've told me, and I don't want her to lose her Social Security or her housing. It seems like she has placement now. Would she have a problem going through pretrial?
No, I think she'd be able to go through pretrial.
Okay, so I'll start with the battery. So for the battery, it'll be a $3,000 SOB through pretrial level 1. No further contact with Timothy Miles. No drugs, alcohol, or weapons while out on bond. I don't see a stay away on here. For the criminal trespass, it will be $1,000 signature bond through pretrial level 1. No further contact with Winston Douglas. If there is a stay away, I don't see one.
There is
but-
not a stay away on either cases, Your Honor. The MARTA restrictions expired in 2021. The other case happened out, I believe, on the street. And so there was not a request for a stay away on that one either.
Okay. No drugs, alcohol, or weapons while out on bond. I don't normally do that, Ms. Porter. I'm going to give you the opportunity, given your special circumstance, and I don't want you to lose your housing or your disability. But if you do not show up for your next hearing date, then you will be right back where you are, and you won't get a signature bond the next time. So if you move or any of that, Ms. Atai, if you'll explain to her that she's going to have to keep in touch with the court to make sure that she doesn't miss her next court date, because I would not want her to be back in the same situation again.
Yes, Your Honor, I will be, I'm in touch with her daughter who's on the call, Ms. Joyner, and
Okay.
I will be in touch with them. Thank you. Thank you.
All right.
And also, excuse me, Ms. Atai, please make sure you put the FTA numbers on those orders along with the case numbers, because she's being held on the FTAs and not the actual case number. So if you can indicate both of those on the
Okay.
order, please.
Okay,
Thank you.
thank you.
Next, we can go to position 19 through 21, Mr. Cruz.
And Ms. Falk, I believe that I saw an email stating that these were going to be dismissed, so do we need?
I have no pros orders prepared, Your Honor. It's my understanding, I've looked at this case as well. This series of incidents has actually been converted to a felony case in Superior Court, where all of these incidents and the victim is the same, and all of the incident dates are identical. So the state would move to null pros these 3 positions based on them being duplicative, and I will send those over shortly.
Okay. Tell me what we're talking about. I'm sorry, I missed where we are.
We are talking about positions 19 through 21.
Okay, so Mr. Cruz, so tell me again, and is it not, there's a private attorney on this, is that not the case?
That was my understanding, but
We thought so, but the private attorney is not handling the misdemeanors.
Okay, so tell me again, Mr. Desiano, I'm not, so what are we doing here?
Your Honor, the state's going to move to null pros all 3 of these cases because
Okay.
this is a duplicate case. There's already a Superior Court case, 24 SC 002967, that involves all of these incidents and the same victim.
Okay, thank you. All right, so Mr. Cruz, these cases, misdemeanors will be null pros. Good luck to you, sir.
Thank you.
Now we can go to position 8 and 9, Mr. Logan.
What are we doing with Mr. Logan today?
Your Honor, he was in Cobb County. I was able to speak with him just this morning. He's held right now on a $4,000 bond for an FTA on the case that's on position 8. I believe he did have a pretrial bond for the underlying case. And Your Honor, he missed the FTA is when he missed court on August 2nd, 2023. And I haven't been able to verify, but he tells me that he was in Cherokee County custody from May 2023 until August 24th, 2023. So if perhaps Miss Hardy could confirm that he was arrested and in custody at that time. I haven't been able to confirm that, but I mean, I think it would be if I had a way time that I could find it. So I would like to ask again, in this case, because he was in custody in Cherokee County, and that's why he missed the court date, to lift the FTA, which is holding him here.
If we can get some documentation of that, Mr. Ty, I'm sure that Mr. Esiano would consider that in this matter. Maybe we could get it resolved. Is there a way that we can find out? Ms. Hardy, can you assist us on this?
The only thing I'm seeing, the GCIC shows that he was arrested May 30th, 2023 in Cherokee. But it doesn't give me like the length that he was there, anything like that.
Ms. Hardy, what was his last conviction? Because he says on August 24th, 2023, he pled guilty to a theft by, I think it's a theft by taking or a theft by receiving.
I have a 2023 theft by receiving that he got first offender on.
And when was the date on that? Because that's when he was released from Cherokee County.
Let's see.
Thank you for your help.
Your Honor, I'm showing that he pled on August 17th of 2023. However, I would still, we can contact the jail and get confirmation that way. I would just like some proof that he was actually incarcerated during that time, and I have no problem consenting to lifting the bench warrant at that point, but I would like some kind of receipt or confirmation for that. Otherwise, of course, I would ask that you do what you normally do and just return it to the division judge, who's Judge Morrison.
So
yeah, I don't, if this is the only thing holding him here, that's why I was asking you, Your Honor, to lift it based on this information, because it'll take time to have that.
okay, I'm going to lift it. If you can't get it while we're in court today, if you can get it later in the day and you let me know, then I'm happy to lift it at that point. But if you'll try to get that, okay, even if you can't get it done during our court session today, later on in the day or whenever, if you get it to me or get it to Mr. Esiano, then I'm agreeable to lifting it once you have the proof for the state, okay?
Okay, thank you, Your Honor. I will get that to you and Ms. Deciano.
All right, good luck to you, Mr. Logan.
And also, Judge, in the system, apparently Judge Morrison, case manager, put in a note on August the 21st of 2023 saying the defendant was incarcerated. We set the case further notice, but that was on August the 21st of 2023. But he missed court on December the 6th of 2023. That's where the FTA came into play.
I believe the FTA was August 2nd, 2023.
I'm showing it's August 2nd, 2023, but Your Honor, if the note was from the 21st and he apparently pled on the 17th, there's some discrepancy about what happened within those couple days, if he was released or not. So again, this is something that just could be easily cleared up by contacting the Cherokee County Jail.
Okay, so you'll get back to me.
Yes, I will.
All right, who do we have next?
Judge, if we can go to the add-on calendar, positions number 3 and 4. Morrow.
Okay, so we discussed, good morning, Ms. Morrow. I know we discussed your case last week. Mr. Hogan, good morning. Let me see if Mr. White here. Is this Mr. White's case, I believe?
Oh, no, it's mine, Your Honor.
Oh, I'm sorry, Mr. Tom. So we had a discussion last week about Ms. Morrow's case. Have we made any progress?
Yes, Your Honor, she does wish to enter a guilty plea today, but the state's offer includes, reporting to probation, a $500 fine, and I think that you're familiar with Ms. Morrow at this point. And also an anti-theft class. She has been struggling with homelessness and has been a pad participant for several years. She also suffers from MH issues, Your Honor.
Do we need to go into a breakout room to discuss this?
No, Your Honor. She she says that she does receive the therapy and counseling, and she seems very well right now. And I spoke with Gar, and it's a time served offer. So the only thing that I'm asking you to consider is something other than her reporting to probation for the remainder of the time, and she simply cannot afford a $500 fine and doesn't have a phone, would not be able to successfully complete an online anti-theft class. And I just want to state that, you know, for the theft that is allegedly ice cream and chips.
Okay, Ms. Falk?
Yes, Your Honor. I'm just trying to pull up my notes from the last time we were before this court.
And Your Honor, sorry, I should say that I have spoken with Gar from Pat, who is on the line, and Ms. Morrow is fine being released to Pat Wednesday at 9 a.m. rather than these probation and the fine and the anti-theft class, and to just continue working with Pat. And they can pick her up Wednesday at 9 a.m.
Your Honor, I'd like to be heard briefly when you have a moment.
Yes, please. Refresh my recollection, please, Mr. Hogan, regarding what we spoke on last week.
Well, first of all, really able job by counsel on both sides. I'm not speaking to any legal issues, of course. I understanding the calendar's busy, I think the court's question about a breakout room would help a great deal. Last night, very late, kudos to Ms. Atai, was working very late on this one. And I believe actually Ms. Morrow had some ideas about a good resolution good for all, for the state and for Ms. Morrow, but it would be very helpful if we could discuss that in the breakout room.
Counsel?
That's fine.
Yeah, I don't have any objection if there is a proposal on the table. Since this will be the first time I'm hearing it as well.
Okay, so if we could put courtroom 2, Ms. Falk, Mr. Hogan, and myself into a breakout room, please.
And of course, Ms. Atai.
Oh yeah, she's in courtroom 2.
Oh, thanks. Sorry. I need a scorecard to follow the players.
Perfect. Ms. Grace, did you get that?
I'll do it, Judge. I don't know where Ms. Grace is at.
Okay, thank you, Ms. Lewis.
Apologies for my appearance. I'm sitting outside Mercy Care, getting someone to a provider. And if you start hearing some dialogue on my end, it'll mean my client's done with their doctor appointment.
Worry.
Ms. Asatai, are you on a separate,
No, I'm not. I thought they were just gonna put courtroom 2 in the breakout.
I did not know if they wanted, since everybody else is in the courtroom, they will hear everything.
Oh, okay. Well, I gotta be quick. I'm on this device now.
Okay, we're back, ACDC.
Yes, Judge, we're
Yes,
present.
we're still working on Ms. Morrow's case. She's going to be reset until the competency calendar on Thursday. So we will address her again at that time.
Okay, thank you.
Who do we have next?
We can go to back to position 8 and 9. We gotta find out about it.
Olivia?
Oh, we don't have to,
We don't need to call him.
Oh,
We'll
okay.
just email it to.
yeah, he's done.
Miss Desiano, did you have a chance to check your chat?
Just got it.
Okay. Your Honor, I've just been called into a meeting. If I could just step away for about 30 minutes, I've asked Miss Desiano to hold things down while I step out, but I will be back. Thank you.
Okay. Ms. Hawk.
We can go to 42 and 43, Mr. James Ross.
So she's got. Yeah.
Mr. Gilletti's case?
Yeah, Your Honor.
Yes, Judge, sorry about that. I just received proof of incarceration for Mr. Bogan, so I just shared that with everyone who needs it.
Okay. So once you get that, Ms. Desiano, I'll let the court know. And what
I
are we
have it,
doing?
Your Honor. It's fine. Thank you.
Okay, so so the previous bond will be reinstated.
Yes.
Okay. What are we doing with Mr. Ross?
Mr. Ross would like to enter a negotiated plea this morning, Your Honor.
Okay, good morning, Mr. Ross. I'm Judge
Morning.
Eric Moore. Good
Morning.
This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Yes, Mr. Desiano.
Your Honor, for position 42, the state's recommending for count 1, time served 36 days, credit for time served 18 days. That's November 25th to November 28th, 2023. And then July 24th of this year to today. Count 2, 12 months probation, balance suspended. Stay away from all MARTA facilities until January 16th, 2025. In conjunction with the MARTA suspension, and position 43 will be null prost.
Did you let it?
Yes, Judge, we do stipulate to venue basis and factual ID. Factual basis and ID. Mr. Ross understands his MARTA suspension is till January 16th of 2025, and agrees to stay away. So I think we'll have no further issues.
Okay. Mr. Ross, it's my understanding that in case 23 CR 007414E, you wish to plead guilty to certain acts on a bus, rail station prohibited, and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Ross. Good luck to you, sir.
Thank you, sir.
Thank you, Judge.
Thank you.
Thank you.
Who do we have next?
We have position number 1, Mr. Ahmad Rashad.
And this is Ms. Atai's case.
Yes, Your Honor.
Are you filing a waiver?
Yes, Your Honor, I'll file a waiver and this is a not guilty plea.
Okay. Mr. Ahmad, your case will be returned to the division judge. You'll get notification of your next hearing date, sir. Good luck to you.
Number 56, Ms. Williams.
What are we doing with Mrs. Williams, Mr. White?
Judge, first I was gonna ask if you would consider a signature bond for Ms. Williams. She's in, on a DUI and related, offenses. She's been in now for 54 days. She was a bind over from Roswell, and for some reason, we're just now getting to her. This is not an FTA or anything of that sort. And on a first offense DUI, typically that's a 2 or 3 day sentence, and she's already been in 54 at this point. And I did confirm earlier with the state that this is her first DUI arrest. So we're asking that she be allowed to sign her own bond on these charges. I know that typically you would just send it to the division, but this isn't one that was already in division. And I can almost certainly guarantee you that Judge Mather, who is the judge that this is assigned to, would give her a signature bond, and we skip that week of wait if we could and allow her to sign her own bond.
So has she not had a bond within that whole time, Mr. White?
She has, Judge. This is a bind over case. She had a first appearance in municipal court in Roswell. I'll make this easy. I don't have an objection to a signature bond given the number of days that she's been incarcerated. Currently her bond right now is a $3,500 surety bond, which I agree is a bit high for a case like this.
Okay, so Mr. White, if you'll prepare for the DUI, it'll be a $2,000 signature bond through the jail. For each of the other charges, it'll be a $1,000 signature bond through the jail. Makes for a total of a $5,000 signature bond through the jail. No drugs, alcohol, or weapons while out on bond.
Thank you, Ron.
Okay.
Now, what position was this?
This is position 56, Ms. Williams. Ms. Williams, I've given you a signature bond so you can sign yourself out. You'll get notification of your next hearing date, ma'am. Okay, good luck to you.
Thank you, Judge.
Probation ready? Can we start on a probation? What? Can we do the probation now?
This is going to be number 2, Alexander, Shawanda.
Okay. And this is going to be a negotiated plea.
Yes, Your Honor.
Good morning, Ms. Alexander. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Okay. You have to speak up for me or get closer to the camera for me. Okay, say it again, loud. Okay, I'm not able to hear her very well. Is there a problem there at ACDC?
She's just soft-spoken, Judge.
Oh,
She said soft-spoken, Judge.
okay, so you're gonna have to speak up for me, Miss Alexander, okay?
I say yes.
Oh, okay, thank you, ma'am. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, Miss Alexander. You can put your hand down. Thank you. Ms. Desiano?
Your Honor, state's recommendation for position 2 is 12 months probation, serve 84 days, credit for time served 43 days. That's March 23rd to April 18th of 2023, and then July 22nd of this year to today. Balance suspended. Stay away from the Atlanta Best Storage Facility at 2393 Metropolitan Parkway. State will move to null pros, position 3, and it asks the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
We stipulate.
Ms. Alexander, it's my understanding that in case 23 CR 001789F, you wish to plead guilty to criminal trespass. Is that right?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by Ms. Attai. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced you to plead guilty?
No.
I'll accept the plea as negotiated, Miss Alexander. Good luck to you, ma'am.
Thank you.
Next, we could go to position number 22, Mr. David Cummings.
This is also a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Cummings. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning. Yes, I do.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
So help me God.
Okay, thank you. Ms. Essiano?
Your Honor, state's recommendation is 12 months probation, served 34 days, credit for time served 17 days. That's July 22nd of this year to today. Balance suspended. Stay away from the Waffle House at 1227 Virginia Avenue in East Point. And I'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea. Thank you.
We do stipulate, Your Honor, and I'm just remembering I did not talk to Mr. Cummings about how our courtroom discusses plea offers, so I'll just say again for clarity that this plea offer does not request any additional jail time, and the rest of the sentence will be suspended as long as he stays away from the Waffle House on 1227 Virginia Ave, correct?
Okay.
Okay.
Yes.
I usually go over that in advance and I forgot, so I just wanted to make sure we're clear.
Okay, very good. Mr. Cummings, it's my understanding that in case 24 CR 005029J, you wish to plead guilty to criminal trespass. Is that correct?
I do.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
I do, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir, Your Honor.
I'll accept the plea as negotiated, Mr. Cummings. Good luck to you, sir.
Thank you very much.
Thank you, Judge.
Who do we have next?
We can go to medical. We're gonna do position number 26, Henry.
Okay. So, are you gonna file a waiver, Ms. Vigiletti?
Yes, Your Honor, I did send one to Ms. Lewis this morning.
Anything further on Mr. Henry today?
No, Judge, I would love to make a bond argument, but I talked to Mr. Henry about maybe going to a program, and so we may come back to you, request to come back if that comes together. But for now, we're just requesting it be this case be reset to the division judge, Your Honor.
Mr. Henry, your case will be transferred to the division judge. You'll get notification of your next hearing date, sir. Good luck to you.
Next, we will go to position number 1 and 2 on the probation calendar. Mr. Thompson.
Okay. Officer Allen, are you with me?
Yes, Your Honor. How are you doing?
Doing well. I hope you are as well.
Thank you.
And
Mr. Thompson or Ms. Thompson?
Mr.
Thompson.
okay.
Your Honor, Mr. Thompson was sentenced to probation for the charge of theft by taking and simple battery. He was sentenced on September 22nd of 2022, where he's required to report to probation for 12 months, pay probation supervision fees, complete anger management classes, no contact with the victim, and also complete a shoplifting course. Your Honor, the defendant has failed to provide our office with the completion of an anger management course, as well as the shoplifting course. The defendant has been in jail in custody since July the 27th of 2024. is 103 days remaining on his case. Your Honor, at this time, we recommend that the defendant be allowed to complete a 6-hour anger management course and complete a shoplifting course. So we're asking for him to be reinstated to probation.
Okay, Mr. Ty.
Yes, Your Honor, I would just ask that you accept the recommendation of Ms. Allen.
All right, you need to get that anger management and shoplifting done, Mr. Thompson. If you don't do it, or if you don't report to probation and you come back here, then whatever the remainder that you have, I'm gonna revoke it, okay? So I'm gonna give you the opportunity to do right and get this done, but you're only gonna get one opportunity. You understand me?
Okay.
All right.
Your Honor, can we make sure that he provides our office with, because this was cases from 2022, so we will need some contact information.
Okay, and Mr. Ty, can you make sure that probation gets that information, please?
Yes, Your Honor. I believe he is residentially challenged.
Okay, so can we have, so can we get us at least a social worker to see if we can help him with housing? Does he have any type of?
No, Your Honor, he told me that he doesn't have a phone, he doesn't have an address, but I think our social worker for today is gone.
How many days has he been in custody total?
Let's see. He's been in since, it looks like July the 27th. So let me count.
Been in jail for 11 days as it
Yeah,
is.
11 days.
11 days.
11 days. And did he, was he, when he was first arrested, did he have any time in jail?
Give me 1 second.
He received a signature bond, Judge, and he was released. They got him for 1 day. He was booked in 9/18/2020, released 9/18/2020. It was on a signature bond for these charges.
Of course, our notes that he was given credit for 16 days. He actually goes before Judge Morrison on tomorrow. And Your Honor, being that he, unfortunately, he is homeless, he would not be a good candidate to come because these programs cost. So Your Honor, I will ask that this particular case number 22 CR 003096A be time served.
Okay, and that's what the court was inclined to do. So time served. Good luck to you, Mr. Thompson.
Thank you, Your Honor.
Thank you. Your Honor, that concludes my business. May I be excused?
Don't we have a Ricky White? I have a Ricky Wright on my calendar.
Your Honor, I did a whole release on his case. He completed all conditions, so he's already been released.
Okay, very good. Thank you. Have a good day, Officer Allen. Thank you.
All right, you too. Thank you.
Judge, if we can do number 49, Ms. Weems.
Okay. And what are we doing with Ms. Williams today?
Judge, Ms. Williams is going to be a not guilty. I was just able to speak with her this morning, so we'll just, if you can arraign her, and we'll wait formal reading.
Okay. Good morning, Ms. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Ms. Williams, you've been charged in case 21 CR 002845J with battery. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding that you're waiving formal reading of the accusation, Mr. White.
That's correct, Judge.
How do you plead, Ms. Williams? Guilty or not guilty?
Your Honor, I plead not guilty, but I have to take a plea.
Okay, hold on. You have a right to remain silent. That's all I need is your not guilty plea, Ms. Williams. I'll accept the not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Mr. White, it seems as though she wants to say something else, but I don't want her to put herself in more jeopardy.
If they could put her back on the phone, I could talk to her.
Okay, thank you.
Thank you.
All right. Good luck to you, Ms. Williams. We'll have Mr. White call you and talk to you.
Your Honor, I have a question before we move on to the next position.
Yes.
Are we gonna have the Spanish interpreter on today?
Let's see. Ms. Lewis, Ms. Grace, has a Spanish interpreter been requested?
Did not know that we needed one. We'll try to get one.
Exactly. And I just tried and I'll continue to try, Judge.
Okay, well, we're gonna see if we can get one. Okay. Who do I have on the jail court's iPhone?
We have positions 51 to 55, West.
Okay, Mr. White, this is going to be a non-negotiated plea.
Yes, Judge.
Okay. Good morning. And this is Mr. West. Can you hear me okay?
A little bit, I'm trying to.
Okay. I am Judge Eric Morrow. This is a state all-purpose calendar that we're conducting by video. Is it okay with you if we do this by video?
Yes, sir.
Okay, can you raise your right hand for me, please? Can you raise your right hand for me?
Looks like it's frozen, Judge. Oh, there we go.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Ms. Desiano?
Your Honor, is the non-negotiated portion the jail time, I'm assuming?
It is.
Okay. Your Honor, I don't believe there's an objection to the position 51 or 52 as time served. May I just go into the facts of position 53? I think that's what's at issue here.
Yes, that's fine. Before you do that, Ms. Desiano, Ms. Hardy, do you have Mr. West's history for me, please?
Excuse me. Yes, Your Honor, I do. He has 25 arrest cycles in Georgia. Felony conviction in 2012 for aggravated assault, terroristic threats, robbery, possession of a firearm during the commission of a felony. Misdemeanor conviction in 2022 for battery, family violence, disorderly conduct, 2020 simple battery, disorderly conduct. See, and there are 4 probation violations, nothing further to report.
Desiano?
Your Honor, I'm also showing that he has another conviction from 2019 for simple battery. In addition to what pretrial stated. The facts of this case, Your Honor, this incident happened on July 14th of this year. Officers were dispatched to 1350 Mason Turner Road, apartment F15, in response to a dispute. The victim in this case is the defendant's brother, Dontavius Riley. He advised he was standing outside of his apartment when his brother punched him twice in the face. When police arrived, the victim told police that the defendant said he was going to kill as many police officers as he could before shooting himself, based on the threat to the officer's safety. And this individual was barricaded himself in a room. The officers had to evacuate the apartment building. They had to surround it. There was a standoff for a short period of time. The 2 officers were able to talk the defendant into coming out and surrendering. They were speaking to him through a second-story window, and that exchange took about 20 minutes. Your Honor, the state is recommending for position 53, the battery, that he do 12 months probation, serve 90 days, credit for time served 24 days. That's from July 14th this year to today. Balance probated, no further violent contact with his brother, Dontavius Riley, taking complete family violence intervention program per the statute, 40 hours of community service, and no firearms. That recommendation, Your Honor, is based on his history. He has a prior aggravated assault conviction. He has a, let's see, two prior simple battery convictions. He has a battery that was actually reduced from an aggravated assault from 2021. And Your Honor, based on the sentence lengths from his previous cases, I'm showing that in 2021, his battery case, he served 125 days. The state's only asking that he served 90 days in this case, and it is another battery. He also has a prior conviction for battery that was after the 2021 case. However, it's in a different jurisdiction, Your Honor, so I don't know what he was sentenced to in that case. But from what I can see, his most recent battery from this jurisdiction would be a served time of 125 days, and then he was sentenced to 24 months of probation. I think this recommendation is fair considering this defendant's violent history, and I'd ask the court to consider that when determining appropriate jail time. His other cases, Your Honor, for position 51 and position 52, I don't believe there's an objection to either of those. But for the record, those are both time served pleas with no probation. And this is a global recommendation, Your Honor. Some of the things the state takes into consideration, is the offers in the other cases as well, in order to find a fair resolution to all these cases. And I believe the offer in this case is fair. Thank you.
Right.
Okay, Judge, first of all, the state keeps referring to this as a battery. This is a simple battery. There was no injury alleged. Furthermore, the issue with his brother is, to get into this without basically saying that he's not guilty, this is an issue with his brother over an inheritance of a property that he's trying to keep Mr. West away from, which he has legal right to be in. We're not going to get into all of that now, but so we would allege that the entire incident with the brother is not true. But he does want to put all of the cases behind him, and that's why we're entering a plea, and we're just asking that you consider giving him time served for all the cases. We have no issue with any of the probation. He's willing to complete all of that, so it's simply the matter of the time.
He has
I'm sorry.
Go ahead.
I was just going to say the simple battery convictions, he's correct. It is a simple battery, not a battery. For his simple battery convictions, Your Honor, this would be his third offense. And the first, I can't see his second conviction, but his first conviction back in 2019, he was sentenced to 30 days, which is more than the time he's already served at this point. And of course, that we're now 2 offenses later, and actually 3 offenses later, because he had a battery in between that. I'm sorry, 4 offenses later, because he's had 2 batteries in addition to the other 2 simple batteries.
This is the third time we've covered this ground. We're not disputing any of that, Judge. So we've heard his record now 3 different times.
Okay. I am concerned about what the allegations are as far as what followed when the police arrived, Mr. White. I'm willing to given what you've told me as far as the brother, and does he have a place to live, number one?
He does, Judge.
Okay, and it's no further violent contact is what the recommendation is with his brother, Mr. Riley, is my understanding. I'm willing to release him with 48 days. Credit for time served 24 days, but I do want him to have a mental health evaluation. So if
I have a doctor.
Ms. West, don't say anything.
Okay, so if you want to discuss that with him, Mr. White, so I think that might be more more in line with what might be necessary. I'm not sure if it's necessary to keep him in custody any longer, but I would like to do the MHE.
And Judge, I don't think that's unfair.
Okay, so do you want to talk to him about that?
I can try to briefly explain it to him right now, and then
Okay.
if we have to call him. But so, Mr. West, what we talked about yesterday, they're willing to release. The judge is willing to not require you to do any more time in jail. But of all the things that we talked about on probation, the one thing he does want to add is a mental health evaluation and any treatment that may they deem necessary for that. Are you okay with that?
Yes, sir.
That's just a yes or no question. Okay, then we all right, then we will accept that, Judge. He's good.
Okay. Anything further before I take the pleas?
Nothing.
Your Honor, I just asked for you to sound for Mr. Riley.
Okay, if Mr. Dontavius Riley is present and wishes to address the court, now is your opportunity. Mr. West, it's my understanding that in case 21 CR 003568C, you wish to plead guilty to public drunk, simple battery, and criminal trespass. In case 22 CR 007858C, you wish to plead guilty to willful obstruction of law enforcement officers and possession of marijuana less than an ounce. And in case 24 CR 004732C, you wish to plead guilty to simple battery family violence. Is that right?
Yes.
Okay.
Are you under the influence of any drugs or alcohol this morning, Mr. West?
No, sir. No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Quietly, yes, sir.
That's a yes or no question for me, Mr. West.
Yes. Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
In position 51, I'll accept the negotiated plea. In position 52, I'll accept the negotiated plea. In position 53, the court sentence is 12 months to serve 48 days. Credit for time served 24 days. Balance probated. No further violent contact with Dontavius Riley. Family violence intervention course. Mental health evaluation, 40 hours of community service, and no firearms. Okay.
Okay.
Is he working right now, Mr. White?
I was working.
Judge, he was before, and he thinks that he can potentially get back the job.
Okay, given all that he has to do and he's been in custody for a while now, I am going to waive 3 months of the probation fees, which I don't normally do, but I want you to get on your feet, Mr. West. And so I'm going to waive those fees so you can go out, and if you don't have a job, get a job or be able to get your job back. Okay.
I appreciate it.
All right. Good luck to you, sir.
So let me ask you a question. How many more days do I have to do?
No more days. You'll be released within the next 4 hours.
All right. Okay. Thank you.
Welcome. Who do we have next?
We have a position 11 through 13, Mr. Bray.
Oh, wow. That one.
Okay, and let's see. This is a non-negotiated plea.
Yes, Your Honor, it's a non-negotiated plea. Well, first of all, in the recommendations, all of the time is 26 days credit for time served, 13 days. And then at the end, it says total 30 days credit for time served, 13 days. So I don't know if that was a typo or.
That's
or
a
what.
typo, sorry. It should be 26 days credit for time served, 13 days.
Okay, and then, so then no issue with that, it's a time served plea. And then, so okay, and another question that I have, for the add-on, the 19 CR 001937, there's 2 counts, 1 battery family violence and 1 battery, and the counts are merging. So I believe that he should be pleading guilty to battery, not battery family violence. If they merge, he should be pleading guilty to the lesser charge.
So I've been in touch with the victim in this case. The parties lived together when this incident happened. So I believe a plea under family violence would be appropriate. For clarity, I can null pros the second count. It looks like it was charged initially because the family violence relationship was unclear. So there was an either or charge. It's the same incident. So I can null pros the second count if that's easier.
I spoke with the complaining witness. I don't know how long they were living together, but there's nothing in the, the documentation that I saw in the booking report that they lived together. And the complaining witness actually had another address listed with the booking report. The address he had listed is 1306 Brookstone Ridge in College Park. So he had another address.
Your Honor, I had the same questions. He's actually on the Zoom too, if the court wants to inquire, but I did ask him on the Zoom this morning to clarify that they were living together at the time of this incident.
Okay, so we're talking about Donald Anderson.
Yes.
Mr. Anderson, are you with us this morning?
I don't have anyone.
I see you, Mr. Anderson, if you'd like to address the court.
Yeah, I don't know if you can hear me. Yes.
Can you activate your camera?
Hold on. Yeah.
Okay, so raise your right hand for me, Mr. Anderson.
Okay.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, I'm gonna allow the attorneys to question you, Mr. Anderson. They need to answer certain questions, okay? Ms. Desiano?
Mr. Anderson, you recall the incident that happened between you and Mr. Bray?
Yes.
And were you two living together at the time that incident happened?
No.
I asked you that. Remember, I sent you a chat this morning and you said yes?
The incident happened in my house, but we didn't live together. That's what I'm saying. If you understand, I clarified what I clarified.
Have you ever lived with Mr. Bray?
Yes.
Yes.
And when did you live with Mr. Bray?
Years ago on Brookstone Ridge.
Okay, Your Honor, based on that, I would say there's a family violence relationship, the parties having formerly lived together.
I think it's more appropriate to charge it as a battery. And what Ms. Desiano didn't mention is that the complaining witness states that he has no hard feelings. He wants contact. I mean, it's 7 years old, Your Honor. But he's fine. He doesn't want to know contact. He doesn't really even want to be involved. And he said he thinks the charges should have been dropped. So.
Mr. Anderson, do you remember when I asked you if you wanted contact earlier today?
Yes, I did.
And am I understanding correctly that you said that you're not going to ask for contact, but that you don't think that a no contact is appropriate?
If I may, I will read exactly what I replied. Backwards was, I'm not going to say I want contact, but I will say I do not need any orders for stay away or contact with my name or address attached. That was my exact words to you. And my exact to the young lady who, I don't know if it was you or who contacted me on yesterday, I stated that I don't understand why is that this is why I'm being contacted 7 days later, that at this point, I think that I don't need to be, I mean, it don't need to even be a case, because if it's that important for the state, they would have contacted me 7 years ago.
Well, I can appreciate that, sir, and our office will be in touch with you. The reason this case has been delayed as long as it has been is because the defendant failed to show up for court. That's the only reason. But it's safe to say, so I understand that you don't really want to be involved in this case, but you're not seeking to have a continuing contact with Mr. Bray at this point, right?
It doesn't matter. I don't see Mr. Bray or talk to Mr. Bray. I mean, it's very rare I even talk to him. So, like I said, I don't. Yes, he contacted me. Yeah.
Okay, and to be clear, the incident that happened back in a couple years ago, can you tell the court what happened and what injuries you had?
Ma'am, I don't even recall. I'm going to be honest. I'm not going to. I just swore under oath. I don't even recall.
Okay, I don't have any further questions for this witness, Your Honor.
Okay, so what are we doing?
Your Honor, I'm requesting that I mean, he's willing to plead guilty. Of course, I have issues with some of the requirements, like an FVIP. And
But what is he willing to plead guilty to? I guess that's the first question.
A battery, Your Honor, which I think is appropriate. And if the state has written, I mean, their plea offer is that the battery, family violence, and the battery are merging. When those two merge, actually, they merge to the lesser charge, which is battery. So they can't say, oh, no, well, we don't want to merge. Now we are going to null prospect. No, he's willing to plead guilty to battery. He is, of course, motivated to get out today. So, but I think it's proper that he is offering a guilty plea to the battery charge, especially with the uncertainty over whether a battery family violence is even an appropriate charge in this case.
Your Honor, my understanding of merger is that the lesser included charge merges with the more serious offense.
That's not correct.
And if that's not correct, then that was my misunderstanding. I didn't mean to mislead the defense in that, which is why I stated I can null process if that makes it more clear. But I think you just heard the victim testify that these parties used to live together. The officer originally charged this as a battery family violence. This case was accused as a battery family violence. And I believe, per the victim's own words, this meets the criteria to be a battery family violence.
Yeah, he said that they didn't live together.
He said
we don't know that they lived together.
Okay. You know, come on. Y'all can go back and forth on this. You've heard everything. It's up to you, Ms. Desiano, as far as this battery family violence goes. It looks as though that if what I have more of an option to do is, if you can't work out the battery versus the battery family violence, I think it should be a battery. The age of the case, what this man has just said, that he doesn't even want to come to court to testify on the matter, that he doesn't remember what happened. I think if you get a battery on the record for Mr. Bray, then the state's doing good, but that's up to you. What I would do is accept the pleas on the other two, give him a signature bond on this battery family violence battery, and you all work it out somewhere down the road. But that doesn't seem to be the most efficient option to me, but I can't make you do anything that you don't want to do. So,
well, Your Honor, given your opinion on it, if he wants to plead to the battery, I would just ask if the family violence intervention would be converted to anger management.
Okay, that seems like that would be
that's fair.
More than appropriate. Okay,
and Your
thank
Honor, I'm sorry, he's already done a 2-day anger awareness.
Well, I'm gonna require that he does an 8-week anger management course. Okay, in addition to whatever else he's already done. Okay, I think that's a good resolution for everyone. So he'll plead guilty to my understanding, he'll plead guilty to the theft by taking, both of those charges. He'll plead guilty to a battery, and the sentence for the battery will be 8 weeks of anger management, 40 hours of community service with all the other terms.
Yes, Your Honor, and for the two theft by taking, I am objecting to, well, first of all, those are, again, it's 7 years old. I don't know about restitution to Hardee's, Your Honor, in the amount of $80. And there's a stay away from Hardee's. I just think it's silly to order restitution to Hardee's. I believe he was fired and he didn't even get his last paycheck. So that's more than $80 right there.
Well, if he's pleading guilty to a theft by taking, I'm gonna make him do something. So he's gonna do an anti-theft class, and if they're asking for some restitution, Hardee's can take it or not, but if they're asking for restitution and they have an amount, I'm gonna order the restitution also. I don't think that just because the age of the case that he shouldn't do something if he's admitting that he did it.
Okay, Your Honor, that's fine. So the $80 of restitution to Hardee's, I'm sure that will be. Okay, and Your Honor, I'm also requesting that any probations run consecutive. I'm sorry, concurrent.
Okay, I don't have any objection to him getting this behind him in the next year. So they'll all run concurrent, given the age of these cases. We all clear?
Yes.
Anybody have a
Yes, sir.
disagreement with me? If you do, voice it now, please.
I just want to make sure it's clear on the record so Katrina can get it down properly. It was a
I
lot
can
going
go
back
through,
and
I can
forth.
go through it.
Thank you.
If
Thank you,
that's
Ms.
easiest
Esselstyn.
for you. Okay, so he's playing to position 10, 12 months probation, served 26 days, credit for time served 13 days, balance probated, stay away from the Hardee's at 891 Holcomb Bridge Road, take an anti-theft course, pay $53.08 of restitution to Hardee's, position 11, 12 months probation, served 26 days, credit for time served 13 days, balance probated, stay away from the Hardee's at 891 Holcomb Bridge Road, take an anti-theft course, pay $30 of restitution to Hardee's. That'll run concurrent with 17 CR 024918C. Position number, the add-on 19 CR 001937. The count 1 will be, I guess, null prost. Count 2, 12 months probation to run concurrent with 17 CR 024918C. I guess no further violent contact with Donald Anderson. The stay away is not necessary. 8 weeks of anger management, 40 hours of community service, and no firearms. Is that everyone's understanding?
Just understanding that for the second theft by taking, when you say anti-theft course on that one, he wouldn't have to complete that course twice.
Correct, it's concurrent, so one would satisfy the other.
We in agreement, Mr. Ty?
Yes, Your Honor.
Okay, very good. Anything further before I take the plea?
Your Honor, I just asked the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
We stipulate, Your Honor. Thank you.
Okay. Joe, of course, iPhone, could you unmute, please? Mr. Bray, let me first apologize. I'm sorry I haven't addressed you. We're talking about you as if you're not standing right there in front of us. So good morning, Mr. Bray. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, yeah.
Can you hear me, Mr. Bray?
Now I can, yes, before I could.
Okay. Yes, good morning. We're doing this by video. Is that okay with you?
Yes.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Miss Atai, we've had a good bit of conversation about Mr. Bray that might have changed some things. Do you need to speak with him before I take this plea to make sure that he understands?
No, I don't need to speak with him. We've discussed everything from the worst outcome to the best outcome, so it's all been covered. Thank you.
Okay, all right, very good. Mr. Bray, in case 17 CR 024918C, it's my understanding that you wish to plead guilty to theft by taking. In case 17 CR 024919C, you wish to plead guilty to theft by taking. And in case 19 CR 001937, you wish to plead guilty to battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Bray. Good luck to you, sir.
Thank you.
Who do we have next?
Next, we have position number 23 and number 1 and 2 on add-on calendar.
Sorry, what position?
Okay, 23 on the regular calendar and add on 1 and 2. It's my
Thank you.
understanding that you're going to file a waiver, Ms. Vigiletti, is that right?
Yes, Your Honor. I did waive Mr. Davenport's presence. We did speak yesterday. He's aware of the situation.
Mr. Davenport, your case is going to be returned to the division judge. You'll get notification of your next hearing date, sir. Good luck to you.
Position number 33, this is McCrae.
This is going to be a negotiated plea.
Yes, Your Honor.
Yes, good morning, Mr. McCrae. Can you hear me okay?
Yes, sir.
I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Raise your right hand for me, please. The other one? You're fine. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hand down, Mr. McCrae. Thank you. Yes, Ms. Desiano.
Your Honor, state's recommendation is time served, 278 days, credit for time served, 139 days. That's March 21st of this year to today. And I'd ask the defense to stipulate to venue factual basis NID.
So stipulated, Your Honor, and nothing further to add.
Okay, Mr. McCrae, it's my understanding that in case 24 CR 005303E, you wish to plead guilty to willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. McCrae. Good luck to you, sir.
Thank you.
You're welcome.
Next, we have position number 14, Mr. Cartwright.
Okay.
And Your Honor, for this case, I emailed Ms. Bach last night, and I just forwarded that to you, Ms. Desiano. We have an NOD on count 2. And I can't, I mean, in looking at the hearings, I don't see where a 4,000, I mean, he's held on a $4,000 bond on, I guess, the criminal trespass family violence, but I don't see when that bond was set and how that got there. And I don't know if we may need some more time. He has another hearing coming up on August 13th. So he's here until then. If we need to reset this to figure out what's going on, because I have an NOD for count 2. And I don't know where this $4,000 bond that he's being held on for the criminal trespass. But he is willing to plead guilty, and I would say to a criminal trespass. I've not seen a criminal trespass family violence, just for a time served.
So I'm showing the simple battery family violence, the NOD that you're referring to, is a totally separate incident. And that was NOD'd based on the statute of limitations.
What's the incident date? What's the incident date?
The incident date, let's see. January 30th, 2022.
I don't see it.
And then the one before the court today is has an incident date of August 2nd, 2021.
Hold on, I think that's not.
And then looks like there was another simple battery family violence that was NOD'd that has an incident date of December 4th, 2021. And it looks like those were NOD'd because they were delayed arrests and the defendant had a residence in Georgia throughout that time. So there's no exception to the statute of limitations.
And if you had a question about the bond, this case was.
And the bond, okay, so it's looking like, I'm not showing that there's an active FTA case, but I did write down that there was a failure to appear of Judge Roth's compliance calendar on May 25th, 2022.
And it was a bond surrender from pretrial team.
Okay.
But what amount is the bond surrender?
I guess the amount that he was given back on August the 2nd of 2021. The original bond was a $5,000 pretrial warrant signed per Judge Morrow back on August the 2nd of 2021.
But then he's held on a $4,000 bond.
One charge, well, the criminal trespass family violence was $1,000 pretrial per judge, and the battery family first offense was a $4,000 pretrial per judge, which made a total of $5,000 per judge total bond, and I guess pretrial surrendered him on the bond amount.
But so the battery family violence is a $0 bond right now, and that's why his bond is $4,000. I
guess I don't know what they were referring to. Maybe they didn't have the bond amount altogether. Maybe they didn't have the bond amount for the battery family violence, but the battery family violence, like I indicated, was, I guess that's an overall total that they got on there, but I think the jail is incorrect.
I agree. I'm looking at the bench warrant from his FTA. The bench warrant has just a surety bond of $4,000.
And I don't see that he was served on that FTA, and it's not on the calendar today.
Well, I have a note that he had a failure to appear, but it doesn't look like there's not a case associated with it. That happens from time to time, but I mean, he's in jail, so.
Cartwright.
So what are we doing, Mr. Ty?
Well, I mean, I think with this amount of there's not a lot of clarity of what's going on here. I don't know how there's a $4,000 bond and then a $0 bond on the family violence, but at this point, he is willing to plead guilty to a criminal trespass. And he was told, Your Honor, when he was arrested, that it was the battery family violence was dismissed, but I don't know about restitution, but just a time served. And I think that that's fair in this case, because if documentation goes missing and we don't know where, something came from, he has an FTA. I don't know what's going on, but I would say a time served and he's willing to plead guilty to criminal trespass.
I mean, Your Honor, I
said
found
yes,
the bench warrant on the jailing screen. It's not missing. It's right there.
He's being held on a bench warrant?
Yeah, it was a pretrial. He was not compliant. It was a pretrial warrant that was issued out, and the total of the share, they changed it to a surety bond, total overall $4,000. I'm looking at the actual bench warrant.
But
And that's from Judge Roth back on May the 25th. It was issued on May 25th of 2022. It says he failed to comply with pretrial compliance. He was on a pretrial compliance counter with Judge Roth, and apparently he failed to comply. So they issue a $4,000 total of overall for both charges. So that's why you see a zero amount on there. So it's a total for both charges of $4,000.
Your Honor, I think that this just needs to be reset either until Tuesday.
Okay, we'll reset it till next Tuesday.
Because if there is an FTA, it needs to be dismissed also. And I'm not seeing that here.
Okay. Next Tuesday is the 13th. It'll be reset until August 13th. We'll see you back next week, sir. What do you have next? So I take it that we're not going to get a Spanish interpreter today?
And Judge, he has an immigration hold anyway, so it's not doing any harm to reset the case.
Okay, when would you like it reset until?
You tell me, whatever's easiest for everybody. Like I said, he's got another hold. It's not going anywhere.
And what position are we talking about, please?
The Spanish interpreter case, 44.
Okay. So we'll also reset him a week till August 13th. Okay, anyone else that we can take right now? Did the 11 o'clock, is Mr. Charles Houston with us?
Yes, sir.
Yes, this is a DV bench warrant case. Who's representing Mr. Houston today?
I did.
Oh.
Mr. White, are you with me?
I am, Judge.
We have since no one else has come on for the SAP calendar, let's go to the DV bench warrant calendar. This is Charles Houston. Who represents Mr. Houston?
I will be, Judge.
Okay, have you had the opportunity to speak with him?
I have not.
Okay, do you have anybody in courtroom there with you? Do you need me to
There's
place you?
nobody. We can go. There's nobody.
Okay, so why don't we, Mr. Houston, I'm gonna place you into a breakout room with Mr. White there so you can discuss your case, okay?
Okay.
All right, so if we can place Mr. Houston in courtroom 2 into a breakout room, court will be in recess.
Okay, Judge.
Thank you, Ms. Grace. Court will be in recess until they return.
Do I need to do something, or is he just gonna pop in here? Mr. Houston, can you hear me?
Yes, sir.
All right. So you missed the court appearance
Well, I
You're,
didn't.
you're not in the breakout room yet,
Oh,
Mr. White. Hold on. She got to open up the room. Hold on. Melissa, are you putting them in the breakout room or am I?
I'm trying, but yeah, I got it.
Who we got left?
Your Honor, if I may interrupt quickly, is it possible for myself to be put in a breakout room with jail clerk iPhone while you address this matter with the bench warrant? Thank you.
Of course, so we'll place Ms. Vigiletti's iPad and jail court's iPhone into a breakout room, please.
Okay, Judge.
Thank you. And is Mr. Houston back out of the breakout room?
Yes, sir. I'm here.
Judge.
Ms. Desiano, are you with me?
Yes, Judge, I'm here.
Yes, I understand that Mr. Houston missed a court date.
Yes, Your Honor, he missed a plea arraignment. I'm sorry, plea arraignment calendar on July 3rd of this year.
July 3rd.
In Judge Roth's courtroom. I'm not showing any returned mail.
And Judge, he never received notice for that. He did go to court on July 15th for what he thought was this, where there was also a traffic offense, if I understand correctly. But anyway, there's confusion. He didn't receive notice. He's with us here today. I've also got an address just to make sure we have the right one. But we'd ask to allow him to go back and to court on his next court date. He definitely did not do this intentionally.
Desiano, what address do you have there so I can make?
Sorry.
Go ahead.
Hold on a second.
Uh-oh.
1169 Owen Court, Jonesboro, Georgia, 3023 something. 8. Yeah.
238. Yeah, that's the correct address.
Okay. Not sure why he didn't get the notice, but Mr. Houston, I'll set it aside. This court normally sets aside the first when you first miss a court date, so we'll do that with this. Make sure that you continue to check in with the court so that you don't miss another court date. Okay.
Yes, sir.
I did explain to him that he can check online and call in every couple of weeks just to make sure, because I mean there are issues with the mail right now, and a lot of people aren't receiving it. So
yes, okay, we'll set it aside, Mr. Houston. Good luck to you, sir.
Thank you. You have a good day.
Do the same.
This is Madrano.
Say it again.
Last name Madrano.
So positions 34 and 35. What are we doing with Mr. Madrano today, Ms. Vigiletti?
Your Honor, I'm not sure if this is going to be a negotiated or a non-negotiated plea. I've exchanged some emails with the solicitors about it. I know, Ms. Desiano, this wasn't originally your case.
Yes, if I could just have 1 second to review. Ms. Vigiletti forwarded me the emails. Okay, so
Ready?
Your Honor, I apologize. If I could have 1 moment to talk to my victim advocate. I know the issue this morning was Ms. Vigiletti is asking that the balance be suspended. And the only issue that the state had with that is that there was damage to the window in this case. And we just wanted to confirm that the victim was made whole and paid for the damage. It's my understanding that Ms. Vigiletti has spoken to her. We were just trying to get confirmation from her.
Yes,
And I'm not
she's
sure.
here as well. Yep, she's on Zoom. Sachiel is her name.
Oh,
so
here we go.
she's present. Yep.
Okay.
So, Ms. Gonzalez, are you with me? Can you come on camera, please, ma'am?
And I know she's been on quite a while. I'm gonna send her a text real quick because she's been on a couple of hours, so I'll just make sure she's. Oh, I think she's with us.
Hi, I can't
Yeah.
take off my video. It says the host has disabled it.
Can we enable her video, please? Oh, there you go. Yes, ma'am. Can you raise your right hand for me?
Yes.
Do you swear affirm the testimony you have to give before this court, the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can place your hands down. Thank you, ma'am. Ms. Desiano?
Yes, Your Honor. Just some notes on this case. What position is this on the calendar?
This is position 34.
Thank you.
Believe that you were going to ask her about restitution?
Yes. Ms. Gonzalez, in this case, the defendant damaged your window. Has he paid you back for that?
Yes.
Okay. And you're okay with having contact with him at this point?
Yes.
Okay. So what Mr. Madrano's attorney is asking for is, instead of Mr. Madrano to be on probation, that now that you've been paid back, that he will no longer be subject to probation terms as long as he doesn't have any more incidents with you. Are you agreeable to that?
Yes, ma'am.
Okay. Your Honor, then this can be a negotiated plea.
Okay. Good morning, Mr. Madrano. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, that's correct.
Okay, you can place your hand down. Ms. Desiano, anything further?
Your Honor, I'll just make the offer clear for the record, and Ms. Vigiletti, please correct me if I'm mistaken. I'm just gonna, so 12 months probation, served 26 days, credit for time served 13 days, balance suspended, no further violent contact with Sachiel Gonzalez. And did you talk to Ms. Falk about the MHET?
If the balance is suspended, we typically suspend all the terms. I will say that Mr. Madrano is 6 months sober, so I think that he has already on his own addressed the underlying cause of this issue.
Okay, Your Honor, so it would just be 12 months probation, served 26 days, credit for time served 13 days, balance suspended, no further violent contact with Sachiel Gonzalez. And I'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
So stipulated.
Mr. Madrano, it's my understanding that in case 24 CR 0000717A, you wish to plead guilty to criminal trespass. Is that correct? Did you hear me, sir? Mr. Madrano, can you hear me?
No, what was that?
It's my understanding that you wish to plead guilty to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes. I understand.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Madrano. Good luck to you, sir.
Thank you.
Thank you, Judge.
Thank you, Ms. Gonzalez. You're free to go this morning.
Thank you.
Your Honor, we have, position number 27. We may have to reset him. He just wouldn't act right when I went up there. He was on 6 months.
Who?
I'm sorry, could you repeat who we're talking about?
Position number 27, Mr. Violet.
Oh, God. He was a lot better yesterday. What's the issue with Mr. Jarrell's or?
Well, I went up there to 6 North and he just wasn't acting right.
We had him on camera earlier. Okay. Judge, can we get him on a Thursday calendar? He's got one more, technically with his plea, he's got one more day anyway.
Okay, so.
Today, and this is the second time he's been reset.
Right.
Y'all asked for a social worker last time. That's the reason why it was reset. A social worker visit, you remember, Judge, from last week?
Right, yeah, so I take it that he had a social worker visit to try to,
They did speak with him, and I believe there's somebody from Pat also spoke with him, but he is, in my opinion, he understands what's going on. He wants to plead.
I remember Miss Gerald's, so she was
yeah
with us last week, and I was concerned because of some of the things that she was saying.
There are issues there, but she's highly intelligent, and understands what's going on, but there are issues, but I don't think they're enough to keep her here.
Right, but I was concerned more about what she was telling me at the time, and that a social worker visit with her, so that I could get a report back that I wasn't gonna put her on the street so that she could harm herself.
And when I spoke to her last night, she's very cogent. So I'm not sure what's happened in the interim, but
okay. Well,
but if we could get just on the Thursday calendar would be best.
Okay, so 8 reset. All right. What, and position number 45, we don't need position 45, is that right? That's gonna be a waiver.
That's correct, Judge.
Okay, and position 46, has that been transferred?
It has, Judge.
Okay.
I didn't see no transfer order yet for 46. I don't personally have that.
Okay. So Ms. Dancino,
Your Honor, I'll have to text Ms. Falk about that because she's been in touch with the DA's office, and I'm not sure if they've
Are we talking
accepted
about
it.
46 Trauman?
He's signing on now, Judge.
yes.
I saw the order.
Okay, so it had been.
Yes.
Okay, so as soon as I get that order, we'll get it signed.
Okay.
And have we missed anyone? I have that we've taken care of everyone. Is that right?
I believe so, Your Honor.
Okay, you're right on time, Ms. Falk.
Yeah, thanks for the help.
Ms. Lewis, whenever you're ready.
Oh, Ms. Fox, I know you just came in late. I just want to clarify on position 46. I did not get the actual transfer order. I saw the information you sent yesterday, but that was not for that individual, it was for another individual. That was Arnold something from the SCA counter yesterday, but it had position number 46 information at the top.
My apologies. Let me make sure I sent.
I didn't, that order didn't have that name attached to it. It had a whole nother name.
Yeah, Anthony Russell. That we got
Yeah.
two, and I clearly We got two on the same day, so I just sent you the wrong one. Let me just send you the other one.
Yeah, because I didn't get that yet.
Understood. I
Please
will send
share.
it momentarily.
Okay. Okay. Starting with the DV calendar, the case has been reset, bench warrant set aside for the notice. On the probation revocation calendar, position 1 and 2 was commute to time served. Position 3 and 4, defendant was released. On my add-on calendar, position 1 and 2, defendant waiver arraignment reset for trial further notice. Position number 3 is going to be a add-on to the compliance calendar. The competency calendar for August the 8th. Starting with the original calendar, position number 1, I have waiver arraignment reset for trial further notice. Position number 2 was a plea. Position number 3 was null pros. Position number 4 and 5 is going to be set to the competency calendar for August the 29th. I did receive the evaluations orders to be signed. Position number 6 and 7 was released. Position number 8, I guess I'll be proof incarceration was sent. I guess I need to get a set aside order for the FTA, and we are reinstating his pretrial signature bond. Is that correct? That's on Mr. Bogan.
That's my understanding.
So I just want to make sure the orders is correct. Now I have an order to set aside the FTA and an order indicating to reinstate his pretrial signature bond underneath the same conditions. PD?
Yes.
Okay. Okay. So that will be for position 8 and 9. Position number 10 was a plea. Position number 11 was a plea. It was an add-on, 19 CR 00193 7, I guess. That also was a plea. Position 12 and 13 were null pros. Position number 14 is reset for the SAP for August the 13th. Position 15 was a plea. 16 was null pros. Position 17 and 18, the defendant was released. Position number 19, 20, and 21 was null pros. Position 22 was a plea. Position 23, defendant waiver arraignment, reset for trial for the notice. Position 24 was a plea. Position 25 was null pros. Position 26, defendant waiver arraignment, reset for trial for the notice. Position 27 is going to be an add-on for Thursday SAP counter, which is August the 8th. Position 29 was a plea. Position 28, was a plea. 29 was a plea. Position number 30 was null pros. Position 31 was null pros. What we're doing with position 32?
Mr. Johnson has a felony matter that he wanted to make sure that he was doing the right thing by both matters. So he did give me permission to request a 1-week reset today, so I can get in touch with that felony attorney.
Okay, so that'll be August the 13th. That will be next week, next Tuesday. Position number 33 was a plea. Position 34 was a plea. Position 35 was null pros. Position 36 and 37, defendant was released. Position 38, I have an amended bond order of $3,000 for pretrial level 1 plus they waiver arraignment reset for trial further notice. Position 39, I have a amended bond order of $1,000 through pretrial level 1 waiver arraignment reset for trial further notice. Position number 40 and 41, reset further notice, waiver arraignment, reset for trial. Also, when you do those, orders, please indicate the FTA numbers on them. Position number 42 was a plea. Position 43 was non-pros. Position number 44, I guess we reset into August the 13th for a Spanish interpreter. Position 45 with the announcement.
Was a waiver.
Waiver arraignment set for trial further notice. Position 46, case is transferred to the DA. Position 47 was a plea. Position 48 was non-pros. Position 49, 40, 49, 50, defendant waiver arraignment. Defendant was arraigned, sorry. We set for trial further notice. Position 51, 52 was a plea. Also 53 was a non-negotiated plea. Position 54 was non-pros. Position 55 was non-pros. Position 56 was a reset for the notice, amended bond order to a $5,000 SOB through the jail, 2,000 on the DUI, 1,000 on the plea, 1,000 on the reckless driving, and 1,000 on failed to yield the right of way. And I did receive that order. Thank you.
Can you give,
The breakdown
can you
again?
give a total, no, not the breakdown, total amount, please.
5,000 SOB through the jail.
Okay.
Position 57 and 58, defendant was arraigned, not guilty, reset for trial further notice. Also 59, defendant was arraigned, not guilty, reset for trial further notice. Any questions or concerns or corrections?
For position 16, did you get the plea for the add-on that we did, the last minute add-on?
I'm sorry. Yeah, that's right. Yeah, I do have.
I'm sorry, position 15, not 16.
Yeah, the global situation on the add-on for the Christian. For the other charge, which I do have. There's, the case number off that, but I got it down. I don't know the case number. The case number was 24 CR 003808A, which was for Robert Coleman, additional charge for criminal trespass. He entered a plea. And I think that take care of that. I did get it. I just didn't write it down all the way.
I just sent you an email saying that was the last order, but I lied. Now it's I'm sending you another email that's actually the last order.
Yeah, I need
Sorry.
some more orders. That's correct.
And I did send you the appropriate transfer order for Troutman.
Thank you. I appreciate that one too. Let's see, anything else? Mr. White, I guess I need a waiver. You indicated a waiver of one of the individual cases.
Gotcha.
I didn't get the last two ones either. Can you send those for the last counter too? I think I sent you an email on those two. I never received them.
I didn't, I think we actually waived the others in court. This is.
No, that I had made note that you waived their arraignment on one of those two, and the one you just did. You said you waived their arraignment, and well, the other two was arraigned. So I need the paperwork on that, please.
Okay.
I mean, I'll send you an email if you can't remember.
Sure.
Okay.
Okay, nothing further. You have a good rest of your morning. See you next time.
Thank you.
Thank you.
Guys.
Thank you.